Good day, Crime Talk aficionados. It is Saturday, February 19th, 2022. What does that mean? That's right. It's the huge weekly recap of all the top stories that we brought you throughout the week, all conveniently located in one safe place. Thanks for watching. We'll see you next time on Crime Talk. Now, let's get to the docket. A couple of things have taken place. I think we're actually going to get, that's right, we're actually going to get some progress in the Daybell matter, since we know that Lori Vallow probably isn't going to join us for a while, or at a minimum, probably not going to join us for several months, to say the least. First, the court issued an order basically sealing the records regarding the dissemination of material regarding the medical records for Lori Vallow. It's a long way of saying basically we're not going to release to the public anything related to her medical evaluations that are ongoing. But I can tell you, and I will tell you that this is not unusual. This is quite normal because everybody has a right to privacy when it comes to their medical records. Obviously, by statute, all these reports go to the defense counsel, the prosecutor, as well as the court to make any determination as to whether somebody is in fact competent. The mere fact that we're still getting reports and they're not delivering Lori Vallow back to the county jail indicates she is still not competent to proceed. We're going to do a video on that tomorrow explaining the competency process and what are the tests that they use regarding malingering to show that well, in fact, she is not malingering. And I say I don't think she is because there's a lot of professionals out there. They see malingering. They know what it looks like. And I'm pretty certain this is not it. The court also set a hearing regarding the motion to dismiss that's been filed by the defense. I don't think actually anything's ever really been filed. Court dates and deadlines have been set, but it always seems to get extended. But March 23rd at 9:30 a.m., there will be a hearing. We will bring it to you live. So all our Crime Talk staff will put that on our calendars. And then finally, the defense, on behalf of Daybell, has filed a motion for severance. Now, you may say, what's severance, Scott? Severance is when you are joined in the same indictment as Daybell is with Lori Vallow. You're asking for the court to sever the trials. But and let's face it, the case can go forward without Lori Vallow. But what Mr. Pryor is requesting in this particular hearing is don't allow anything in regarding the alleged bad conduct of Lori Vallow. Now, that seems to be a little difficult because, well, this whole case revolves around Lori Vallow, and whether she is there or not, there's going to have to be information that is going to come in about that. Now, obviously, we don't have all the information that the defense attorney has, but I would think that this would be a good defense tactic for Mr. Pryor to say, bring it all in. Let's say how crazy Lori Vallow is. And look, she fooled everybody, including her own attorney. And what are the odds that she fooled Mr. Daybell? And her brother was probably crazy too. Lay it out there. You have to embrace the bad facts when it comes to preparing your defense. And basically what they're asking for is don't allow in 404B evidence throughout the trial. We all talked about that. That's the other crimes, wrongs, or misconduct. But there's things called res gestae, something that the court says is so intertwined to this case that although prejudicial, the probative value outweighs any prejudicial effect on the defendant, and therefore it should come in to help give context to the entire circumstance. We'll have to wait and see what the court rules on this motion, but my thinking is it's a little bit premature for this to be filed and severance issues to be resolved just yet. Obviously, when the court rules or any further filings come about, we will let you know. First on the docket, that's right, it was just getting going. We were asking for proof of photographs, and then something happened. That's right, a settlement has been announced. Prince Andrew has announced that he is settling his lawsuit with Virginia Roberts The undisclosed deal includes Prince Andrew making a substantial donation to Ms. Roberts' charity in support of victims' rights and even praised her bravery. He never intended to malign her character. Ms. Roberts sued Prince Andrew last August, alleging that he, that's right, did terrible things to her when she was 17, and that the man named Jeff was allegedly involved in the trafficking of Miss Roberts. Now, Prince Andrew, who's 61, said in a statement that he, quote, regrets his association with that guy named Jeff and pledged to demonstrate this by supporting the fight against the evils of sex trafficking by supporting its victims. Attorney David Boyce, who represents Roberts, said in a filing that lawyers on both sides were telling the judge that a settlement in principle has been reached and that they will request a dismissal of the lawsuit within the next 30 days. The settlement means that the civil case will not go to a jury trial and that the Prince Andrew will no longer be questioned under oath by Miss Roberts' attorneys. Now, Buckingham Palace declined to comment on the developments today, but the news will no doubt have come to some relief to the Queen and other royal officials. And it will also spare the prince from a potentially embarrassing series of disclosures and accusations in the months ahead during the trial. It was also reported overnight that Miss Roberts claims to have lost the original print of the famous photograph of her and Andrew taken in London in 2001, which could further the Duke's argument that the image was altered. Now, in the full statement, the prince intends to make a substantial donation to Miss Roberts' charity in support of victims' rights. Prince Andrew has never intended to malign Miss Roberts' character, and he accepts that she has suffered both as an established victim of abuse and a result of unfair public attack. It is known that that guy named Jeff trafficked countless young girls over many years. Prince Andrew regrets his association with that guy named Jeff and commends the bravery of Miss Roberts and other survivors in standing up for themselves. He pledged to demonstrate his regret for his association with that guy named Jeff by supporting the fight against the evils of sex trafficking and by supporting its victims. Wow, ladies and gentlemen, what does that really mean? Well, if she didn't and couldn't find the actual photograph, that certainly may have been somewhat of a defining or watershed moment in that case. But at the end of the day, everybody gets what they want. Ms. Robert gets the prince giving her money for her foundation, and also gets a statement saying that he regrets his association with that guy named Jeff. Well, there you go. Everybody gets what they want, and the prince makes the matter go away without any public statements other than we are going our separate ways, and Miss Roberts is obviously a victim of sexual abuse by that guy named Jeff, and so the prince gets away with basically paying some money and making the whole suit go away. But that's what civil suits do. It's all about the money. Always about the money, ladies and gentlemen. Next on the docket, Sandy Hook. That's right. Family of the victims of the Sandy Hook massacre reached a settlement with Remington Arms Company, the manufacturer of the rifle used in the 2012 mass shooting. Now, the insurers of the rifle company agreed to pay the full coverage available, which was $73 million. The families say that they can also now make thousands of pages of internal company documents public, which they prove Remington's wrongdoing. One of the lawyers behind the family's legal strategy to pierce that immunity said that the settlement would send a message for the gun industry to stop recklessly marketing all guns to all people for all uses, and instead ask how marketing can lower risk rather than court it. Now, for the insurance and banking industry, it is a time to recognize that financial costs of underwriting companies that elevate profit by elevating risk could be risky. The attorneys went on and said, our hope is that the victory will be the first boulder in the avalanche that forces change. The settlement comes after more than half a decade of bitterly contested litigation. A judge initially dismissed the family's complaint in 2016, but their lawsuit was revived on appeal, leading to a Supreme Court battle there in the state. Now, normally gun manufacturers have immunity. There's federal legislation that says you cannot be held responsible as a gun manufacturer if somebody uses in a criminal act. I mean, it makes sense. We don't hold Ford accountable or Chevy accountable when somebody drives through a crowd of people and saying, you marketed your car in such a way that this was a manly truck and that you could do anything and drive anywhere. Because that's really what they were saying was the marketing that this gun made you powerful and manly, and therefore that led to the shooting. Obviously, it was a tragedy that took place at Sandy Hook. It never should have happened, and the people that should be held responsible will never be held responsible in a court of law. But the gun manufacturer, that's kind of a little bit of a stretch. And normally those insurance companies don't pay out $73 million. But maybe we'll get to see these documents will be released, and maybe it'll change my mind. I'm just a little surprised by it. That's all. All right. First, let's get to the docket. You want to talk about some royal dough? Yeah, let's do that. Well, as we brought to you the other day, the now disgraced British royal Prince Andrew was urged to disappear forever from public life after settling a sexual assault lawsuit. As Queen Elizabeth II has suffered some further indignity in her Platinum Jubilee year, Queen Elizabeth, who is reportedly helping to foot the bill for the Andrew settlement, also saw her elder son, Prince Charles, embroiled in fresh controversy over a cash for honor scandal. Police in London say they are investigating claims that an aide to Charles offered UK honors and even citizenship to a Saudi tycoon in return for donations to charitable foundations run by Prince Charles. Well, it's good to know that you have corruption all around the world. It's not just here in the United States where people make donations to foundations that get all kinds of money when they're running for president, and then when they lose, it all stops. Well, these revelations came after Charles Younger's brother, Andrew, settled his lawsuit brought by the Virginia Jeffries, sparing him the public humiliation of a trial. The settlement is rumored to be £12 million. What does that translate to? Yeah, $16.3 million. Miss Roberts and £2 million for victims of sex trafficking. Now, according to the Daily Telegraph, the money will come from private estates belonging to Queen Elizabeth. And British media called on Prince Andrew to withdraw entirely from public life after he was already stripped of his honorary military ranks and his title of His Royal Highness. It's good to know things never change. People always ask me, Scott, who pays for the legal fees of your clients? And you know what I have to say? I say, thank God for parents and grandparents. And it's good to know that for Prince Andrew, a 60-something-year-old guy, I think he's 61, his mom is still coming to the rescue. Some people could say that'd be a little bit of TMM at 61. That's right, too much mommy. But what do you expect from a guy who's never really done anything in his 61 years other than be a member of the, lucky sperm club? That's about it. Okay, as you may know, the Lori Vallow-Daybell case, the motion for a change of venue has been granted previously by the court. The prosecutors objected. And they strenuously objected. And they said, really, Judge, we want to have more time. And the court said, you had your opportunity to present evidence and you didn't convince me otherwise. But the court said they would wait and see. Well, now the prosecution has filed, and I have a copy of it here in my hot little hands, a supplement and disclosure for the state's motion for the court to allow additional evidence and follow Idaho Code 19-18-16 by transporting a jury. They just don't want to try Lori Vallow and Chad Daybell in Ada County. Now you may say, why? Are the people in Ada County, Idaho, unfair? No. The prosecutors are okay with the jury coming from Ada, Idaho. They just don't want to try the case there. Why, you may ask, Scott? What does Scott always say? It's always about the money. And this is exactly the reason why the prosecutors say, hey, let's just pick a jury in Ada County and let's move them back down here to Fremont County where we can conduct the trial. And how much money is it going to cost? Well, the prosecutors have asked the sheriff to come up with a cost estimate, and it's broken down in their attachments. But basically, they're saying that they're going to have 14 sheriff personnel will have to go to Ada County to cover the trial. That'll be a bailiff in the courtroom, transportation to and from the jail, transportation, security of witnesses, assisting in courtroom as far as door security, and jury transportation, security, and sequestration. All things that, the sheriff usually has to do when they're at their home. And what is the cost that the sheriff is estimating that it will cost the good people of Fremont County? $269,430. However, If they just did the jury selection in Ada County and then shipped them back down to Fremont County, it would only cost $53,444, a savings of $215,986. This is a good teachable moment. When you bring high-profile cases, the people that fund the district attorney's offices, usually the county commissioners in which the jurisdiction in which they reside, is responsible for that responsibility. So the district attorney then has to go to the county commissioners and say, hey, we're going to need some more money. And the county commissioner is going to say, wow, this seems kind of expensive because you kind of turned this into a whole big circus. And wow, that's a lot of money. And as my first boss told me in the military when I was saying, sir, do we really want to prosecute this case? The witnesses have since scattered all over the world. It's going to cost a lot of time and money to bring them back. Is it really, really worth it? And you know what my boss told me then? The colonel looked at me as I was a young lieutenant captain at the time. He looked at me and he said, justice is expensive. Now, the prosecutors should just foot the bill in this particular case. They brought this case. They charged it. They knew it was going to be high publicity when they did it. It's just the cost of doing business. We'll see what the judge will do in this particular case. Judge Boyce seems to get real wishy-washy, and I'm not sure he's going to have the guts to say, no, let's do it. And the prosecution's motion is basically, hey, we asked all these other prosecutors what they've done, and they found no authority that says that it's somehow going to be reversible error if we try the case in Fremont County and then we pick the jury in Ada County. Well, of course, you have to then consider the disruption to the jurors who are going to have to move to the other side of the state, live in a hotel, possibly be sequestered as well. I hope the judge errs on the side of the jury inconveniences and tells the county to foot the bill. All right. Thanks for watching. Hope you enjoyed this week's shows. We'll see you next time on Crime Talk.